सुस्वागतम. कार्यक्रम सुरू करण्यापूर्वी 2 लाईन सादर करते. कार्यक्रम स्मरणार्थ दादांच्या आपल्या होते सुरू व्याख्यानमाला. पाहुण्यांच्या आगमनात उल्हास वाढला वनमंदिरात. करते मनोभावे आपले सर्वांचे स्वागत या न्याय मंदिरात, या न्याय मंदिरात. ॲडव्होकेट धैर्यशील पाटील दादा यांच्या स्मरणार्थ व्याख्यानमालाचे शुभारंभ. या कार्यक्रमाचे प्रथम पुष्प माननीय व्यासपीठ नामदार न्यायमूर्ती उच्च न्यायालय मुंबई डॉक्टर नीला गोखले साहेब, सातारा जिल्ह्याचे प्रमुख जिल्हा न्यायाधीश सुरेखा पोसनकर साहेब, तसेच सातारा जिल्ह्यातील सर्व वरिष्ठ व कनिष्ठ न्यायाधीश साहेब, सातारा जिल्हा बारचे अध्यक्ष ॲडव्होकेट सयाजीराव घाडगे सर व उपाध्यक्ष ॲडव्होकेट ज्ञानेश्वर नलवडे सर व इतर पदाधिकारी, तसेच ॲडव्होकेट सिद्धार्थ धैर्यशील पाटील सर व त्यांचे कुटुंबीय सदस्य व सर्व सातारा जिल्हा बारचे सदस्य, या सर्वांचे व्याख्यानमाला कार्यक्रमामध्ये स्वागत आहे. तर दादांबद्दल आपण दादांना प्रेमाने दादा म्हणतो. त्यांचं नाव ॲडव्होकेट धैर्यशील पाटील दादा असं म्हणतो. हे सातारा जिल्हा बारचे सदस्य, महाराष्ट्र व गोवाचे सदस्य व बार काउन्सिल ऑफ इंडियाचे माजी अध्यक्ष होते. त्यांच्या स्मरणात वकील बंधू भगिनींसाठी व्याख्यानमाला आपण सुरू करत आहोत. आपण या कार्यक्रमाची सुरुवात दीप प्रज्वलन व दादांच्या छायाचित्रास पुष्पहार अर्पण करून करूया. तर मी सर्व मान्यवरांना विनंती करते की दीप प्रज्वलनासाठी व छायाचित्रास पुष्पहार अर्पण करावे. पाटील सर यांना आपण सर्व दादांचे सुपुत्र म्हणून ओळखतो. दादांचा वकिलीचा वारसा सिद्धार्थ पाटील सर हे यशस्वीपणे चालवत आहेत. त्यांनी ॲडव्होकेट पाटील सर यांना विनंती करते की त्यांनी प्रमुख पाहुण्यांची ओळख करून द्यावी, तसेच व्याख्यानमालाबद्दलही माहिती द्यावी.
Your lady Justice Dr. Neela Gokhale, Honorable Principal District and Session Judge Kosunkar Madam, all respected judges of the Satara District Court, Family Court, and other courts who are present today here in the court hall. President of the Satara District Bar Association, Shri Dhairyasheel Gadge, Vice President, committee members of the Satara District Bar Association, respected senior members of the bar, my dear friends and guests. I am extremely happy for this opportunity to address this wonderful bar. Though I practice mainly in Pune, I take pride in calling Satara as my parent bar. It is with immense joy and emotion that I welcome you all to the first memorial lecture series in honor of my beloved father, late Shri Dhairyasheel Vitthalrao Patil, who was not only my guide and senior, but also my mentor and friend. I am pretty sure that many of you who have gathered here would have had some opportunity to interact with him or at least seen him in action in the court. My father, Dhairyasheel Patil, who everyone fondly called Dada. But for the benefit of many youngsters who are new in the bar, I would like to say a few words about him before I say a few words about our chief guest today. Dada was a second generation lawyer. His father, Vitthalrao Patil, himself had been a very renowned lawyer. Though some may say that Dada was handed everything on a platter, nothing would be further from the truth. Dada, though he studied in a Marathi medium municipality school, out of sheer hard work and determination, not only developed immense fluency over the English language, but also built his own practice and soon became one of the leading criminal lawyers, not only in Satara, but throughout Maharashtra. Dada was one of the finest criminal lawyers Maharashtra has seen. Dada was known for his art of cross-examination, and I would rate him as one of the best cross-examiners I have seen in my practice. He had an unusual style of cross-examination, which was to the point and never lengthy. I have personally seen him mesmerize judges with his arguments. For the legal community here today, you are well aware of the impact of my father, the impact my father had in the field of law. His formidable presence in the courtroom, wearing a dignified gown, commanded respect from judges and fellow lawyers alike. He was a mentor to many, and he believed in the importance of passing on knowledge to the next generation. He always managed to take time out from his busy schedule to teach the students of Ismail Saib Mullah Law College here in Satara, where he was an honorary professor since 1971. He was also an active faculty at the National Judicial Academy at Bhopal, where he addressed district and high court judges. He was the first from Satara to be elected as a member of the Bar Council of Maharashtra and Goa in the year 1985, a post he held till 2004. During this period, he was selected as a member of the Bar Council of India between 1987 to 1998. In 1998, he was elected as the chairman of the Bar Council of India. I think till date, he is only the second lawyer after Advocate Ram Jetmalani from Maharashtra to hold this esteemed post. Now, all these achievements, especially as a member of the Bar Council of Maharashtra and Goa, would not have been possible without the unwavering and unconditional support of this bar, his colleagues and friends who stood by him throughout his journey. I remember that on each of the 3 times that he contested elections for the Bar Council, he was elected with the highest number of votes most of the votes coming from this bar. And for that reason, our family will eternally be grateful to this bar. I would say that the crowning glory of my father's illustrious career came when the Bar Council of Maharashtra and Goa, in appreciation of his contribution to the legal profession, conferred upon him the very first Vidhi Maharshi Lifetime Achievement Award in April 2022. Dada passed away on 14th of September 2022 at Satara. On his demise, when I say we, I mean my family members, members of the bar, his friends, we felt it was only fitting to commemorate his legacy through something meaningful and lasting. Thus was born the idea of a lecture series, one that not only honors his memory but also upholds the values so close to his heart. We hope this lecture series becomes a platform for thought-provoking dialogue and a space where legal practitioners and jurists can exchange ideas that enrich the legal community, just as Dada would have wanted. We have decided to have this lecture once in a year, ideally in the month of July, because that will coincide with his birthday, which falls on the 14th of this month. Now I'll introduce the chief guest for today's lecture. Our chief guest for today, Honorable Justice Dr. Neela Gokhale, was born in Pune and completed her law from ILS Law College and further did her LLM from Savitribai Phule Pune University. Your Ladyship has also done her doctorate in domestic and international adoptions from Bundelkhand University at Jhansi. Your Ladyship enrolled herself as an advocate in 1992 and joined the chambers of Senior Advocate Mr. Ajit Kulkarni in Pune and started practice in various courts in Pune and would also appear before the Honorable Bombay High Court. Your Ladyship, apart from her law practice, was also actively involved in facilitating rehabilitation of distraught women, single mothers, and adoption of children as a part of the Mahila Seva Mandal in Pune. After her marriage to an army officer who is presently serving as a colonel, Mr. Kedar Gokhale, your Ladyship moved to Delhi and started practicing before the Honorable Supreme Court, where your lady specialized in constitutional cases, adoption cases, criminal cases, public interest litigation, and cases relating to the armed forces. Your Ladyship was a visiting faculty in Indian Law Institute at New Delhi, where she taught for nearly 8 years before being elevated as an additional judge of the Honorable Bombay High Court on 30th January 2023. Since her elevation, your Ladyship has been sitting either as a single judge or on a division bench, mostly handling criminal matters. Your Ladyship has given several landmark judgments, like directing the government to put up prison and police manuals online to help prisoners learn more about their rights, ordering the constitution of a SIT to probe the alleged fake encounter in Badlapur. In fact, this very week, her bench upheld the decision of a high-power committee to relocate an elephant called Mahadevi to Vantara for long-term care and rehabilitation, and many such progressive and varied judgments. For this reason, when we decided to have a topic relating to criminal law, the first name which came to our minds was of your Ladyship. I am extremely grateful to your Ladyship, who immediately accepted our invitation and agreed to grace this lecture series. I would also like to take this opportunity to wish your Ladyship a very bright and successful career as a judge. I am also grateful to our Principal District Judge, who happily agreed and encouraged us to arrange this function. I am also grateful to our ex-president, Mr. Vikas Patil, as well as our present President, Mr. Sayajirao Ghadge, committee members and all members of the district, Satara District Bar Association, who immediately agreed to our request to hold this function and have been instrumental in the grand, I won't say the immediately grand success, but from what I can see, the crowd, the hall is totally full. They have been instrumental in the grand success of this program. I thank you from the bottom of my heart for coming here to listen to my leadership, and I am sure everybody is eager to hear today's lecture. With these words, I would like to say thank you. Thank you so much.
धन्यवाद पाटील सर. आपले पाहुणे नामदार न्यायमूर्ती उच्च न्यायालय मुंबई डॉक्टर नीला गोखले साहेबांची ओळख करून दिली व खूप छान पद्धतीने व्याख्यानमालाबद्दल माहिती दिली आणि दादांच्या आठवणींना उजाळा दिला. आता मी प्रमुख जिल्हा न्यायाधीश उसंकर साहेबांना विनंती करते की त्यांनी नामदार न्यायमूर्ती उच्च न्यायालय यांना पुस्तक देऊन सत्कार करावे. धन्यवाद साहेब. आपले सातारा जिल्ह्याचे कौटुंबिक न्यायाधीश मनीषा काळे साहेबांना विनंती करते की त्यांनी कौटुंबिक न्यायालयाच्या वतीने नामदार न्यायमूर्ती उच्च न्यायालय मुंबई डॉक्टर श्रीमती नीला गोखले साहेबांचा सत्कार करावा. धन्यवाद साहेब. आता मी सातारा जिल्हा बारचे अध्यक्ष ॲडव्होकेट सयाजीराव गाडगे सर यांना विनंती करते की त्यांनी नामदार न्यायमूर्ती उच्च न्यायालय मुंबई डॉक्टर श्रीमती नीला गोखले साहेब यांचा सत्कार करावा. धन्यवाद सर. आता मी सातारा जिल्हा बारचे उपाध्यक्ष यांना विनंती करते की त्यांनी सातारा जिल्हा पोलीस न्यायाधीश श्रीमती कोसंकर साहेबांचा सत्कार करावा. धन्यवाद सर. सातारा जिल्हा बारचे अध्यक्ष ॲडव्होकेट सयाजीराव गाडगे सर यांना विनंती आहे की त्यांनी कार्यक्रमाबद्दल व दादांबद्दल आपले मनोगत व्यक्त करावे.
या कार्यक्रमाचे प्रमुख पाहुणे नीला गोखले, या जिल्ह्याचे जिल्हा न्यायाधीश उसंकर मॅडम, तसेच या न्यायालयात जे म्हणून काम करणारे जजेस, या वकील वर्ग संपूर्ण आणि दादांची सर्व फॅमिली, या दादांच्या स्मरणात पहिलं पुष्प आपण आज दादांचा परिचय बराचसा सिद्धार्थ पाटील करून दिलेला आहे. तरी सुद्धा व्यक्तिगत त्यांचं शिक्षण हे पुणे येतं. त्याचे LLB मुंबई युनिव्हर्सिटी आणि मुंबई युनिव्हर्सिटीमध्ये गव्हर्नमेंट लॉ कॉलेज प्रॅक्टिस त्यांनी योगायोग आहे. प्रॅक्टिस त्यांनी 1969 साली आणि त्याच वर्षी आपल्याला जे हे लाभलेले आहे लॉर्डशिप, त्यांचे जन्मदिवस सुद्धा, जन्म सण सुद्धा तेच असावा असं मला वाटतं. कारण मी वाचले मार्केटा त्यामध्ये तसं दिसून आले. दुसरी गोष्ट की दादा धैर्यशील दादा का म्हणतात? दादा ते नुसतं दादा नाही, तर त्यांच्या प्रॅक्टिसमध्ये त्यांनी एवढं नाव कमावलेलं आहे की त्यामुळे ते दादा बनलेले आहेत. शिवाय त्यांनी क्रिमिनल साईडला प्रॅक्टिस केलं. अख्ख्या महाराष्ट्रामध्ये त्यांचे सर्व ठिकाणी केसेस चाललेल्या होत्या. त्यांनी हजारो केसेस अशा चालवलेल्या आहेत आणि त्या सक्षमपणे त्यांना न्याय देण्याचं काम केलेलं आहे. आपण पाहतो की गाजलेले खटल्यामध्ये दादांचं नाव असायचंच आणि त्यापैकी आपली सातारची एक केस होती, सिंधुदुर्गमधली एक केस होती. अशा प्रकारच्या अनेक चांगल्या केसेस त्यांनी चालवल्या आणि त्यामध्ये त्यांना न्याय देण्याचं काम केलं. दादा पर्सनली ते लॉ फॅकल्टीचे डीन होते. 1988 ते 1991 शिवाजी युनिव्हर्सिटी. पुन्हा प्रोफेसर म्हणून मुला लॉ कॉलेज आपले सातारचे आहे, तर प्रोफेसर म्हणून ते काम केलं. तसंच चेअरमन म्हणून बार कमिशन ऑफ इंडियाचे ते बरेच दिवस चेअरमन होते. तसेच महाराष्ट्र आणि गोवा बार कमिशन ते 20 वर्ष सदस्य. त्याचप्रमाणे त्यांनी त्यांच्या करिअरमध्ये पुस्तकं लिहिली. म्हणजे ते लेखक होते, आपल्याला माहिती नसेल त्याने बरेचसे पुस्तकं लिहिलेली आहेत. कायद्यावर पुस्तकं लिहिलेली आहेत, सोशल जस्टिसवर पुस्तकं लिहिलेली आहेत किंवा आणखी त्यांची हिस्ट्री या विषयावर पुस्तकं लिहिलेली. आणि एक महत्वाचं म्हणजे की त्यांनी एक सिरीज सुरू केलेली होती, टीव्हीला लाईव्ह आपल्याला पाहायला मिळत होतं, की त्याचं नाव आहे भूमिस. तर याचे एपिसोड जर आपण पाहिले तर ते एपिसोड कशा होते, तर सिनेमा, पुन्हा सोशल जस्टिस किंवा आणखी सामाजिक कार्य जे काय काय असेल त्याच्यावर होते. शिवाय इंटरनॅशनल पॉलिटिक्सवर होते. असे त्यांनी 8 वर्ष प्रत्येक शनिवारी त्यांचा एपिसोड असायचा आणि ते लोकल चॅनलला दिसत होते. म्हणजे 8 वर्ष हा कार्यक्रम चाललेला होता. तो इतका सुंदर कार्यक्रमात फेमस झालेला होता की त्याची आठवण म्हणून दादांचे खरंच ते अत्यंत कौतुकास्पद काम आहे. अशा प्रकारचे तसेच दादा हे नुसते प्रॅक्टिसमध्ये दादा नव्हते, तर ते गोरगरिबांचे दादा होते. कारण त्यांनी इंडस्ट्रीयल कामगार जे असतात त्यांच्याविषयी किंवा त्यांच्या ज्या समस्या आहेत त्याच्याविषयी काम केलेलं आहे. नगरपालिकेचे जे कर्मचारी असतात त्यांच्याविषयी त्यांच्याविषयी त्यांचे जे प्रश्न आहेत ते मांडलेले होते. अशा प्रकारे ते युनियनचे सुद्धा लिडरशिप करीत होते. परंतु त्यांनी त्या लोकांना न्याय देण्यासाठी त्यांच्याकडून कधीही पैसा घेतला नाही. अशा प्रकारचे हे दादा, म्हणजे ते एकाच क्षेत्रामध्ये दादा नव्हते, तर ते अनेक क्षेत्रामधले एक इमिनंट लॉयर म्हणून त्यांना दादा म्हणतात. नाहीतर आत्ताची पॉलिटिक्स मधले दादा पाहता येतो कसे आहेत ते. परंतु ह्या दादांना खरंच पहिलं पुष्प गुंतवत असताना अतिशय मनपूर्वक त्यांना म्हणजे हे द्यावं वाटतं, श्रद्धांजली द्यावी वाटते. आणि इतकं सुंदर त्यांनी या महाराष्ट्रासाठी, या बारसाठी, बारचं आमचं नाव महाराष्ट्रामध्ये या दादांच्या मुळे गेलेलं आहे. अशा दादांच्या स्मरणार्थ हे पुष्प आपण गुंतवत आहोत आणि हे पुष्प पुढं कंटिन्यू दरवर्षी लॉर्डशिपच्या हस्ते किंवा आणखी कोणाच्या हस्ते सुद्धा हे चालू ठेवलं जाईल अशी मी ग्वाही देतो आणि माझे 2 शब्द संपवतो.
धन्यवाद सर. आम्हा ज्युनियर्सना दादांबद्दल माहीत नव्हतं, ते माहिती तुम्ही सांगितली. आता BNSS या नवीन विषयावर मार्गदर्शन घेण्यासाठी आपण सर्वजण आतुरतेने वाट पाहत आहोत. तर मी प्रमुख वक्ते नामदार न्यायमूर्ती उच्च न्यायालय मुंबई डॉक्टर नीला गोखले साहेब यांना आमंत्रित करते की त्यांनी BMSS 2023 A New Era in Criminal Procedure या विषयावर मार्गदर्शन करावे.
Before I start addressing anything, I'm really grateful for Siddharth, for the Patil family, for actually starting this academic pursuit, which is definitely bound to help and in fact urge young lawyers and the bar of Satara, especially the juniors, to remain in touch with academics and excel in the field of law. Thank you very much, Siddharth, and thank you very much the entire team. He introduced me to all the juniors, which comprise of Mr. Patil's office, and the way he's been taking it forward. Thank you very much. Really honored to be here. Honorable Srimati Kulankar, the Principal District Judge, the Honorable President of the Bar Association, other office members of the bar, the family members of Shri Dhairyasheel Patil's family, senior the other members of the bar and the bench, learned invitees, ladies and gentlemen. Senior lawyer Mr. Dhairyasheel Vitthalrao Patil, a name that I believe, even in his absence, continues to inspire integrity and commitment to justice in the entire Maharashtra legal community and more particularly in the Satara bar. It is an honor to be here today to deliver the inaugural memorial lecture as a way to honor the memory to the eminent legal luminary. A scholar, actually much has been said about him, and I had not been fortunate enough to meet him when he was practicing now, since I was in Pune. But through Siddharth, the way I have seen Siddharth come up, and the principles and the ethics and the morals of the profession that he imbibes is definitely a tribute to his father and the path that he has shown him. But everything that I have been told about Shri Dhairyasheel Patil is what I have actually researched and found that it's much more than that. I've been told that he obtained his BA honours from Pune University and went on to graduate with first class in law from Bombay University from GLC. His legal career, which began in 1969, soon distinguished him as one of the finest criminal lawyers of his generation. He appeared in sessions trials across the state as well as in the Bombay High Court. A dedicated academician, he served as Dean Faculty of Law, Shivaji University, and was an honorary professor at IMS Mullah Law College, Satara from 1971. He also sat on the boards of various universities and the Academic Council of the National Law School of India in Bangalore. In fact, as the President said, that his television show Bhumi Shilp, addressing social political issues, ran on for 8 years. And I strongly suggest and urge Siddharth and his team to start some pursuit as such in the like manner, because addressing these sensitive issues is actually the need of the day. Today, as we reflect on the legislative reform and procedural justice, it is only fitting that the topic of the first memorial lecture be an ode to the memory of his glorious career. On 1st July 2024, the BNSS 2023 formally replaced the Code of Civil Criminal Procedure 1973, marking a generational shift in India's procedural criminal law. It is part of a triad of reformative legislations alongside the Bharatiya Sanhita and the Bharatiya Suraksha Adhiniyam. As we gather here in the post-colonial constitutional movement of India's legal evolution, we are reminded of the timeless words of Justice Krishna Iyer, and he said, Procedure is the handmaid of justice, meaning that procedural rules are meant to serve justice and not to hinder it. The BNSS endeavors to reflect this philosophy by streamlining criminal processes, by integrating technology, enforcing timelines, and balancing rights with efficiency. The BNSS also aims to establish a justice system that has a greater vitesse and efficiency that can tackle ongoing challenges of complex procedures, case pendency, low conviction rates, lack of technology adoption, and delayed justice delivery system. Above all, the greatest objective of the BNSS is the protection of citizens from unfair exploitation of the procedure possible through the existing loopholes in the current criminal procedural regime. The BNSS mostly preserves the original provisions of the CRPC. However, it aims to simplify the procedural aspects, reduce the trial durations, enhance investigatory powers of the police, implement timelines for procedure, etc. The law basically seeks to 1. Ensure access to justice by reducing procedural delays. 2. Introduce technology and forensic services in investigations, summons, evidences, and its collection. And 3. Protect the rights of victims and accused alike and shift the process from a colonial deterrence-based model to a citizen-centric, rehabilitative, and a transparent justice mechanism. There are a whole lot of provisions which we all read. They are there in the BNSS Act itself, so I will not take you and bore you through all of them because you are all well versed, such an expert and a very specialized bar in criminal law. So I will not take you through all of them, but a very few, I'll just highlight a few provisions which mark a prominent shift. The certain key procedural innovations. The BNSS retains much of the structural framework of CRPC, but introduces several key reforms that merit attention. One of it is a time-bound investigation and time-bound stages of a trial. The framing of charges in 60 days. Judgments by Sessions Court within 30 days of final arguments, extendable up to 45 days. So there's a time limit on even delivering judgments. It's a huge this thing on us, on this side, but probably that was the need of the hour. And uploading of the judgment copy within 7 days. Then the provision relating to a trial in absentia. Section 356 enables in absentia trials of proclaimed offenders post a 90-day waiting period which is aimed at reducing procedural obstruction by absconders. Earlier in CRPC there was no way, and there was such a long delay because of accused who were not before the court and who were absconding. In the entire trials, the docket used to really be full, and there used to be so many procedural delays. Even for the benefit of the other co-accused, this is a very innovative and a very time-based provision. Then there have been victim-centric reforms. It's just not just Article 21 is not only for the accused. If they have been in jail for a lot of time, release them. It's not like that. The law has to basically look at victims as well. Article 21 also protects victims. Now, certain aspects of BNSS have tried to address that aspect as well. Victims must be informed of progress of investigation within a period of 90 days. Withdrawal from prosecution is not permitted without hearing the victim. And the victim is also entitled to a copy of the FIR and documents, also via electronic means. Then there has been an integration of technology and forensics, which is a digital leap. Perhaps the most far-reaching contribution of the BNSS is the embedding of digital processes and forensic mandates into the justice system. 1. E-FIR and Zero FIR, that is Section 173, the old 154. FIRs now can be filed electronically across jurisdictions. So a police station cannot now say that we are not going to register your FIR because the offence does not come within our jurisdiction. Whatever it may be, they are bound to register a Zero FIR and then transmit that FIR to the proper police station within the jurisdiction of the appropriate jurisdiction for its investigation. Then there is a mandatory videography of search and seizure to be sent to the magistrate. Mandatory forensic collection at crime scenes for heinous offences. That's section 176(3). Then audio and video recording of searches, which if you have come across the judgment of Delhi High Court, wherein this was challenged. There was a lawyer in whose office the police had raided his office, taken away all his computers and all the electronic data, and then there was a huge issue regarding the privacy of the clients vis-a-vis that particular lawyer. And then there were rules and guidelines laid down by the Delhi High Court, but now structurally and statutorily they have been incorporated in the BNSS as well. Then in respect of audio and video recordings of searches, confessions and witness statements, rape victim statements at her chosen location, evidence in sessions trial and warrant cases, examination of the accused and framing of charges, all can be done through VC, and the courts are empowered to conduct entire proceedings electronically. Also, the issuance of summons, recording of evidence and the appellate hearings can also be conducted electronically. Recently, as you all must have known, the first 5 courts in the High Court, one of the benches is, I'm sitting with the second court, and all 5 benches have started live streaming. So I'm sure all of you are aware of that, and everything is not in BNSS, but that's a parallel provision, picked up from the reformative laws. So all this marks a significant departure from the physical manual model of the past and aligns with the judicial infrastructure upgrades underway across the country. There are certain safeguards and concerns with regard to maintaining a constitutional balance. So no legislation is immune to scrutiny. Certain provisions of BNSS have invited informed debate. For example, the provision regarding a preliminary inquiry at the time of registration of FIR. So section 173(3) permits a 14-day preliminary inquiry before registration of FIR for offences punishable up to between 3 to 7 years. Critics argue this dilutes the Supreme Court's ruling in Lalita Kumari's case, where FIR registration was mandatory for whenever a cognizable offence was revealed. Supporters of BNSS, however, view it as a safeguard against frivolous complaints in sensitive cases, such as matrimonial cases or medical negligence cases. So this newly introduced provision in the BNSS has given statutory recognition to the procedure of conducting preliminary inquiry by a police officer. This debate has been going on in legal circles as to how this provision can be reconciled with the judgment given by the Supreme Court in the case of Lalita Kumari, and whether this preliminary inquiry envisaged a new provision has to be conducted before or after the registration of FIR. Then there are all these cases which have happened. There was I'll just quickly take through whatever the relevant decisions of various high courts in the country, such as the Rajasthan High Court, the Kerala High Court, Bombay High Court, in respect of whether this should be a huge complex question as to if the offence has been committed prior to 1st July 24 and the FIR has been registered thereafter, after 24, then whether the trial would be under BNSS or under the old CRPC. Then there have been complex issues which have arisen in respect of matters wherein if the offence is registered under BNSS, offence committed prior to the enactment or prior to the notification on which date this act has come into force, but what happens to the bail applications? Or if a trial has commenced and has proceeded under CRPC, then the appellate proceedings will be conducted as per BNSS or by the CRPC. So various high courts in the country have given various views. I think ultimately it is the Supreme Court which has to take a call and decide which and lay down the correct interpretation. I'll just quickly take you through those. Regarding pending cases and offences committed prior to coming to force of the BNSS is concerned, the Rajasthan High Court held that if a FIR is registered prior to 1st July 24, the subsequent investigation and trial procedure qua such FIR shall be governed by the CRPC and not the BNSS. To the turn of the 9, the Punjab and Haryana High Court, the Kerala High Court and the Allahabad High Court have taken the view that only the particular stage of an investigating proceeding pending as on 1st July 2024 shall be carried out or adjudicated in terms of the CRPC, and all subsequent or resulting proceedings shall be carried out and governed by the VLSS. Moreover, an investigation being carried out in terms of the CRPC would be tried in terms of the VLSS. Interestingly, while at first blush these high courts appear to be of the same view, a closer read of the fine print discloses a clear divergence of the views of each of these courts. Now, Section 531, that's the old 482 of the BNSS, appears to be the provision at the eye of the storm. In terms of the repeal and 531 is in respect of the repeal of the original, the old CRPC and the advent of the new law. This is particularly the aspect which is debatable. In terms of the repeal and savings clause under Section 531(1) of the BNSS, the CRPC stands repealed with the enforcement of the BNSS. However, notwithstanding the repeal, under Section 531(2)(a) of the BNSS, if any appeal, application, trial, inquiry or investigation is pending prior to 1st July 2024, the same shall be disposed of, continued, held or made as the case may be in accordance with the CRPC. It is this repeal and savings clause that has fallen for the consideration of various courts across the country. As far as we are concerned, whatever the Bombay High Court has said probably rules the field till the Supreme Court eventually decides. The Bombay High Court in Chogole and Company Private Limited versus State of Goa was inter alia seized of this issue, especially whether a bail application filed after 1st July 2024 relating to an FIR registered prior to said date was to be governed by the CRPC or the BNSS. And in this regard, the Bombay High Court has held that on registration of an FIR prior to 1st July 2024, the investigation began and was pending. Such an investigation must conclude under the provisions of the CRPC, as if the provisions of BNSS 2023 are not on the statute book as on their date and has not come into force. However, a bail application filed post 1st July 24 will have to be considered as an application under Section 482 of the BNSS. So there again, they have distinguished between the hearing of the bail application, the process to be followed while hearing a bail application, and the trial itself. It would surely be interesting to note how this issue is finally resolved. Probably a case-to-case approach may lead to a myopic view of the larger issue. Given the conflict in views of the various high courts, the time may be ripe for the Supreme Court to step in and decide the issue holistically before further conflicting views arise across the country. Now for the role of the bar and the bench. The role is very important. For the bar, these reforms necessitate reorientation, both in procedural practice and digital adaptation. For the bench, they call for active interpretation, especially where liberties are in question. This Sanhita must not be viewed as a mere procedural statute. It is a constitutional instrument meant to serve substantive justice. The ease of doing justice must never compromise the quality of fairness or justice. To return where we began, the BNSS is not an arrow shot in the dark. It is a legislative attempt to modernize, Indianize, humanize our criminal procedural law. But as with any other law, its real success lies in its spirit of application. In the coming months and the years, it will be the collective responsibility of the judges, lawyers, law enforcement agencies, and the civil society to ensure that these reforms translate into meaningful justice, not just faster but fairer. Let us ensure that this new era in criminal procedure is not only defined by timelines and technology, but also by dignity, due process, and the trust in the rule of law. Thank you very much, Jai Hind.
धन्यवाद साहेब. आपण खूप चांगल्या पद्धतीने मार्गदर्शन केले व हे मार्गदर्शन सर्वांसाठी मुलाचे ठरले. आता मी सातारा जिल्हा बारचे उपाध्यक्षांना विनंती करते त्यांनी आभार प्रदर्शन करावे.
व्यासपीठावर उपस्थित मुंबई उच्च न्यायालयाचे न्यायमूर्ती डॉक्टर मीरा भोसले, आपल्या प्रमुख जिल्हा न्यायाधीश कोसुमकर मॅडम, तसंच आपले जिल्हा बार असोसिएशनचे अध्यक्ष ॲडव्होकेट सैराव गाडगे साहेब आणि सिद्धार्थ पाटील आणि उपस्थित सर्व जजेस तसेच सन्माननीय सदस्य आणि दादांच्या कुटुंबातील सर्व सदस्य. आज दादांच्या स्मृतीच्या प्रथम पुष्प मुक्त गेले आणि त्या संपत असताना त्या कार्यक्रमाचा एक भाग मला मिळाला, त्याचा पहिल्यांदा मला एक आनंद वाटतो. आणि दादांच्या बाबतीत बघितलं तर अख्ख्या संपूर्ण सातारा जिल्ह्यामध्ये अगदी खेड्यापाड्यांपर्यंत दादांचं नाव होतं. वकील म्हणलं की दादा असं एक समीकरण होतं. आणि अशा पद्धतीने दादांच्या फौजदारी प्रॅक्टिसच्या अनुषंगानं भारतीय न्याय संहितेवर आपल्या जस्टिस डॉक्टर मीरा भोसले मॅडम यांनी जे लेक्चर दिलं आणि आपल्याला BS ॲक्टच्या बाबतीत एक वेगळा ॲस्पेक्ट दिला, त्याबद्दल मी आपल्या संयोजकांच्या वतीनं सातारा जिल्हा बार असोसिएशनच्या वतीनं आपलं आभार मानतो. त्याचबरोबर या कार्यक्रमाला आपल्या प्रमुख जिल्हा न्यायाधीश हजर राहिल्यात, तसेच त्यांचा सातारा जिल्हा बार सातारा जिल्ह्यातील सर्व न्यायाधीश, आपले कौटुंबिक न्यायाधीश साहेब हजर राहिले, सरकार न्यायालयातील न्यायाधीश हजर राहिले, तसेच आपण सर्व सन्माननीय सदस्य या कार्यक्रमाला उपस्थित राहून या कार्यक्रमाची शोभा वाढवली, त्याबद्दल मी आपल्या सर्वांचे आभार मानतो आणि कार्यक्रमाचा सन्मान करतो.
बारूमध्ये अल्पोपहाराचा सर्वांनी आस्वाद घ्यायचा आहे. कार्यक्रम संपला असं जाहीर बारूमध्ये सोय केलेली आहे. सर्वांनी अल्पोपहाराचा आस्वाद घ्यावा.
उच्च न्यायालयात वकिलीची तयारी या विषयासंदर्भात उद्या दिनांक 20/7/2025 रोजी मुंबई उच्च न्यायालयाचे न्यायमूर्ती श्री संजय देशमुख हे मार्गदर्शन करणार आहेत. आणि त्यासाठी जे स्थळ आहे ते साई सम्राट कार्यालय कोडोली येथे सकाळी 10 ते 12 आहे. तरी सर्व सदस्यांना एक विनंती करतो की या कार्यक्रमासाठी आपण सर्वांनी लाभ घ्या.